Good morning, everybody. My name is Amber Hines. I want to thank you for taking time out of your Wednesday morning to join me to talk about Medicaid planning for individuals that do not have a spouse. Last month, we talked about Medicaid crisis planning for a married couple. So if you missed that webinar and you're interested in a recording of that, you can find that on our website. Today, we're going to be talking about Medicaid crisis planning for individual clients that are not married and don't have a spouse that they can plan for. You can find a copy of today's slides in the handout section of the GoToWebinar dashboard. And if you have any questions as I'm going through today's webinar, feel free to type those into the questions tab of GoToWebinar. I'd be happy to answer those questions. Hopefully we have enough time at the end, but if we don't, I will reach back out to you personally to answer any questions that come up. Again, my name is Amber Hines. My maiden name was Gwen. I may have worked with some of you on Medicaid compliant annuities before. So I have 15 years of experience assisting elder law and estate planning attorneys across the country with Medicaid compliant annuities. Nowadays, I'm only working with A-rated insurance carriers to offer Medicaid compliant annuities, and I'll talk more about that later in the webinar. I am insurance licensed in every state, and I also hold a Series 65 license with FINRA. I created ASHPR specifically to assist attorneys and advisors across the country with pre-planning solutions as well as crisis Medicaid planning solutions. So we're going to start out talking about just basic information about pre-planning for long-term care versus crisis planning. Pre-planning occurs typically when we have an individual that is still healthy. They would still be considered insurable from a long-term care insurance perspective. They're not in need of immediate assistance with activities of daily living, and we don't anticipate them needing long-term care for a while. Pre-planning is always going to be the best option for our clients because it allows them to plan with their assets in the way that they want to, as well as they have more control over the setting in which they receive long-term care. So if they're adamant about never going into a facility and they want to stay at home as long as possible, pre-planning can help achieve those goals. Often when we're looking at a legal planning perspective for clients that are looking to proactively plan or pre-plan for long-term care, this will involve setting up an irrevocable trust and waiting out the 5-year look-back period that Medicaid currently has. The VA currently has a 3-year look-back period for transfers that are made. So basically, we are looking for somebody that has enough time to be able to transfer assets and be able to wait out that time frame before they actually need long-term care. Also, pre-planning, we would always be looking at leveraging assets with long-term care insurance, specifically asset-based policies or hybrid policies. And this, again, means that the person must still be insurable from an insurance standpoint. Asset-based policies are not as stringent from an underwriting standpoint as your traditional long-term care policies, but we still need somebody that's healthy enough to qualify for a long-term care insurance policy if that's something that they're interested in. If we then shift over to a crisis planning model, we're generally trying to qualify a client for Medicaid or veterans benefits in a crisis planning scenario because the person is already in need of long-term care services or in need of assistance with activities of daily living. So at the point that the person needs assistance with ADLs, they're no longer insurable, and we likely won't have enough time for somebody to start transferring assets and waiting out the 5-year look-back period. There's various planning strategies that we can use when we're trying to get somebody eligible for either Medicaid or VA benefits, but it generally is going to involve turning countable assets into non-countable assets, and we're going to talk more about that today. So the different ways that we can pay for long-term care, we can obviously have clients privately pay or self-insure. So basically spend down dollar for dollar. Each dollar that they spend of their own assets is really just going towards their cost of care. It's not really actively helping the client to pre-plan or to plan it all for a long-term care expense, but that is a viable option if they choose to do that. We can also look at long-term care insurance, whether it be a traditional long-term care insurance policy, which is a use it or lose it type of contract that does not have any cash value, or we can look at a hybrid model, which is combining a life insurance or annuity contract together to have a death benefit or an account value if the long-term care benefit is not needed. Also, we would be looking at veterans aid and attendance benefits if we have a veteran or a surviving spouse of a veteran that may be entitled to the aid and attendance benefit. And then finally, we would be looking at Medicaid as well as a payer of long-term care. So today we're talking specifically about crisis planning, and we are focusing on Medicaid planning for an individual client. If we look at the asset and income eligibility requirements, generally the asset limitation for an individual is going to be $2,000 or less. This number does vary slightly by state. So states like Missouri and Nebraska are entitled to a little bit more than the $2,000, and then there's a couple states still that are under that $2,000 limit. But I would say 80% of the states are going to be $2,000 or less that an individual client can keep in their name. If we look at the income limitation for an individual, this is going to depend on whether you are working with clients that reside in a spend down state or an income cap state. So generally, we need the client's total income to be less than their cost of care, unless you live in an income cap state, and we're going to talk more about this, where we have a strict limitation on what the client's gross income can be. And if the gross income is above that current limitation, then we would be looking at setting up a qualified income trust or a Miller trust, as most people know the QIT by. So there are other resources that are protected under a Medicaid plan. We can look at protecting the home, an automobile, personal household goods and personal property, irrevocable funeral trusts, and in some states, IRAs are an exempt asset for Medicaid as well if we have an individual client. I will say that when we are dealing with an individual client versus a married couple, it does become more difficult to protect the home and the automobile if we're looking at the person going on Medicaid, because we have restrictions on how is the home going to be cared for and kept up if the person is contributing their income towards their cost of care. So that can be a little bit more challenging when there's a home or a car involved, when we have just a single Medicaid applicant and there isn't a spouse, where we would be able to kind of shift those assets over to the spouse and have them maintain those assets. So if your client has excess resources, we can spend down assets, or we can develop a Medicaid eligibility plan where they are improving or increasing non-countable assets, such as making improvements to the home, to the car. They can purchase prepaid burial policies, which would be considered an exempt resource. They can pay off credit cards, mortgages, and other debt. And then if they have other resources left over, they can look at purchasing a Medicaid compliant annuity that complies with the Deficit Reduction Act of 2005. If we look at planning, Medicaid planning with annuities, we're always looking at a single premium immediate annuity when we're doing a Medicaid plan. We're not talking about a tax deferred annuity. So there's two basic types of annuity contracts out there. A tax deferred annuity is going to be similar to a CD at a local bank, where a client invests a lump sum of money and is going to grow for a period of time. A single premium immediate annuity is the opposite of that. It is basically the client will deposit, let's just say $100,000 into an immediate annuity with an insurance company. And if they choose to have that paid back over 100 months, the annuity is going to pay the client just over $1,000 per month for that 100 months. So it's basically a way to take a lump sum of resources and assign that to, or transfer that money to an insurance company, and in return, the client is going to receive usually monthly payments, and it converts excess resources for Medicaid planning purposes into strictly an income stream. So once we move that money into the immediate annuity, it's no longer an asset because it's no longer a lump sum of money, it is strictly income. The Deficit Reduction Act of 2005 was the most recent federal legislation that deals with immediate annuities and the strict requirements that must be met in order for the annuity to be considered Medicaid compliant. There are very few insurance companies out there that actually offer a Medicaid compliant annuity. So I will caution you that if your clients are working with a local financial advisor that's telling them that they can do a Medicaid compliant annuity, they're likely just referring to the fact that they can offer an immediate annuity, but it does not have all of the Medicaid qualifying language in there, because there's less than 10 insurance companies right now that offer a Medicaid compliant contract, but there's hundreds of insurance companies out there that offer an immediate annuity. If we look at the language that must be contained within a properly structured immediate annuity so that it meets the Medicaid criteria and so that it's considered a Medicaid compliant contract, you're seeing 5 requirements on your screen now. The annuity must be irrevocable, meaning that we cannot change any aspect of the annuity after it's purchased. So we can't change the payment date, the term, the amount of the annuity payments, or how much is invested into the annuity. We can't change the beneficiary. No aspect of the contract can be changed at all under a true irrevocable Medicaid compliant annuity. Also, the annuity must be non-assignable, meaning that I cannot assign the annuity to a company like J.G. Wentworth or Peachtree, companies that buy annuities on the secondary annuity market. I can't assign a Medicaid compliant contract to a company like that if it has the non-assignable language. The actuarially sound requirement means that the annuity must pay out within the person's Medicaid life expectancy. It can be structured with a shorter time frame than the person's life expectancy, but it cannot be a longer time frame than the life expectancy. Also, the payments must be equal, so we can no longer do a balloon style annuity when we're dealing with a Medicaid compliant contract. And then the state must be listed as the beneficiary to the extent that Medicaid benefits are provided. So we're going to get into what are the planning opportunities involving a Medicaid compliant annuity when we have a single client that does not have a spouse and we're seeking to obtain Medicaid eligibility. There's 2 basic options that we're going to go over today for a single applicant. The first one is going to be a gift and annuity plan, and the second option is going to be a standalone MCA or Medicaid compliant annuity plan. The first option that we're going to go through, you may hear people toss around the terms like half a loaf plan or reverse half a loaf plan. That's essentially what we're doing here, where we're gifting assets and then setting up an annuity to pay through a penalty period. So our case study is dealing with a female by the name of Mary. Mary is 80 years old, and after living at home with dementia for years, she's now in need of nursing home care. Mary's family believes that she could live for another 20 years in this sort of supported care environment. She has total countable resources of $185,000, and these are all after-tax dollars, so we're not dealing with IRA dollars or pre-tax dollars. It's simply money that's sitting in a checking or a savings account. Mary has monthly income of $2,000 from Social Security and a pension. Her cost of care each month is $10,000 per month, and the Medicaid rate at the facility that Mary is at is $8,000 per month. Some states publish the Medicaid rate for each facility, and you can find that on the Medicaid department's website. Others don't publish that information, and you would essentially need to contact the facility to try and find out what the Medicaid reimbursement rate is for your client. Mary's monthly income shortfall, or her deficit each month, is going to be $8,000. We know that the nursing home is charging Mary $10,000 per month, and she only has monthly income of $2,000 per month. So she has a shortfall or a deficit each month of $8,000. If we divide Mary's total countable resources of $185,000 by her $8,000 shortfall, we know that she's going to exhaust all of her resources in less than 2 years. So within 23 months, Mary's going to be completely out of money, and she would go on Medicaid if we don't do any planning at all. But because Mary's family anticipates her living for many more years and they want to preserve as many assets as possible, doing nothing at all is not a great option for her. The first option is going to be the gift and annuity plan. The gift and annuity plan allows a single Medicaid applicant to make an immediate wealth transfer or a gift to his or her intended beneficiaries, and it allows the Medicaid applicant to qualify for Medicaid at the end of an ineligibility or a penalty period associated to making a gift. On this slide, you're seeing a lot of different numbers, and these are calculations that our office can help you to kind of run through. So with this option, we see that Mary has a monthly income shortfall of $8,000 per month. Like we talked about, if we subtract her income of $2,000 from her nursing home costs at $10,000, she is short $8,000 per month from being able to pay her nursing home bill. We then add the shortfall to the divestment penalty divisor in Mary's state of $10,555 per month, and we get the burn rate, or the rate that we are able to gift and use the other amount to purchase the annuity with, so that we're able to maximize the gift amount. If we divide the burn rate of $18,555 by the total countable resources of $185,000, we determined that the ineligibility period is going to be 9.97 months. Generally, I'm going to round this up to the next nearest month so that we get a 10-month time frame, and we multiply that by the divisor of $10,555 to get the gift amount, or $105,552. We then, if we're looking to figure out how much money is going to be left to purchase the annuity with, we're going to subtract Mary's total countable resources of $185,000 by the amount that she's going to gift of $105,000, and we would put the $79,448 into a 10-month annuity, Medicaid compliant annuity, that is going to provide monthly income of $7,955 per month to Mary for 10 months. When we add the amount of income that Mary has from Social Security and pension of $2,000 plus her annuity income of $7,955, her total income is going to be $9,955. By implementing a gift and annuity plan, Mary is going to be ineligible for Medicaid for a time frame of 10 months. This is going to be the private pay or the penalty period. She would have monthly income during this 10-month period of $9,955. And we see by subtracting her total income from her cost of care at $10,000 per month, she has a shortfall of $45 per month. She's going to be ineligible, or she's going to be eligible, excuse me, for Medicaid in month 11. The advantages of doing a gift and annuity plan is that we were able to gift around $105,552 to Mary's children. This is more than 50% of the total asset amount of $185,000. And we're not worried about any real tax consequences in this case because we were dealing with all after-tax dollars that were gifted to Mary's children. It was simply money that was sitting in a checking or a savings account, and we were able to achieve Medicaid or obtain Medicaid eligibility for Mary in month 11. The disadvantages of doing a gift and annuity strategy is if Mary doesn't live through the 10-month time frame that she's going to be ineligible for Medicaid, or the time frame that she's going to be privately paying, then she really didn't gain any economic benefit because Medicaid does not start paying until month 11. So with this case, and as with every other case, life expectancy is always going to be a factor that we consider when we implement a gift and annuity strategy for a client. Many people ask questions about the calculations of why we add certain numbers to the shortfall and the divisor to one another, and how come we can't make exactly the amount of income. Like in my example, there was a $45 monthly income shortfall each month from the annuity and Social Security and pension. So many people ask why we can't make the income equal exactly what the shortfall is. The reason for that is because the Medicaid applicant has to be considered otherwise eligible for Medicaid, but for the fact that they gave a gift or transferred assets in order for Medicaid to start the penalty period. So what does that mean when we say that the person must be otherwise eligible for Medicaid? It means that their income must be less than their cost of care. Their resources must be $2,000 or less in most states, unless you're in a state that has a little bit higher resource limitation. And we also must make a Medicaid application. Once all three of those requirements are met, and the Medicaid application is made, Medicaid is going to start an ineligibility period, and that ineligibility period is going to line up with how long the annuity is structured for. So you recall that in my example, Mary was ineligible for Medicaid for 10 months, and we set up the annuity for a 10-month period to provide almost the amount of income that Mary needed during that 10-month time frame. We can't create exactly the amount of income that the Medicaid applicant needs through the Medicaid compliant annuity, because otherwise Medicaid is going to say that Mary has sufficient income to be able to pay her nursing home bill, and they won't start that penalty period. So that would be a pretty detrimental outcome to doing a gift and annuity plan if we can't actually get Medicaid to start the penalty period or the private pay period. The divisor is another question that a lot of people, there's confusion related to what the divisor is. How do we find that number? So Medicaid is going to calculate the penalty or the ineligibility period based on the total amount transferred or the gift amount, and dividing that by the divisor. So if we add up the gift amount, in this case it was $105,552, and we divide that by the state I was working in at $10,555, and we determined that the penalty period is a 10-month time frame. The penalty divisor is the number that Medicaid says is the average cost of 1 month in a nursing home in your state. This varies as far as whether it's really accurate or not. There are some states that the divisor seems like it is pretty on point with what the cost of care is. And then there's other states where it's extremely low in comparison to what a client is actually privately paying for care. You can find the divisor number either on your state Medicaid department's website or on our website as well. We have all of those numbers published as well. So how does a gift and annuity plan change if your client resides in an income cap state? The long and short of it is that the numbers don't change at all when we're dealing with an income cap state, but there's an extra step that needs to be taken when we are in a state that is an income cap state. So if you live in one of the states that that I'll show on the next slide, you live in an income cap state, which means that Medicaid imposes a limit on the total or the gross amount of income that a client has. The current number for 2020 is $2,349. So in my example, we had total income of $9,955. So clearly, Mary, if she was in an income cap state, is over the gross income limitation. So while the numbers aren't going to change, the annuity payments as well as Mary's other income would need to flow through a qualified income trust or through a Miller trust. And all a Miller trust is really an irrevocable income only trust that is going to hold excess monthly income, and that is going to be used to pay the nursing home each month. So instead of the annuity payments and the Social Security income going directly towards paying the nursing home bill in a non-income cap state, the money is going to go through the Miller Trust in an income cap state before we pay the nursing home. But the annuity income and the Social Security income is being used anyways to cover the cost of care. So while the economic results really don't change, it's just an extra step that must be taken if you have a client that is living in an income cap state. So on this slide here, you're seeing a map of all the states that are in orange are considered income cap states. And pretty much all of the states right now have a limitation of the $2,349 per month, except for Delaware has a different number. But most of them is the $2,300 that you would have to establish an income Miller Trust, excuse me, if your client's income is over that cap. Let's assume now that Mary passes away 6 months after the annuity is purchased. You might recall that one of the requirements of a Medicaid compliant annuity is that the state has to be listed as the primary beneficiary to the extent that Medicaid benefits are provided. Since the annuity was structured for a 10-month time frame and the annuity was being used to privately pay for Mary's nursing home bill, the state, while they have to be listed as a beneficiary, is not going to be entitled to any of the annuity amount if Mary does pass away after 6 months, and anything remaining in the contract is going to flow to Mary's secondary or contingent beneficiaries. So we'll assume that Mary's children are listed as a secondary beneficiary on the contract. They would be entitled to the remaining amount. Now let's assume that Mary passes away 12 months after the MCA is purchased. What happens to the Medicaid compliant annuity? Absolutely nothing. So the annuity, because it was structured for a 10-month time frame, it is only going to pay out for 10 months. So if Mary passes away in month 12, the annuity is already terminated at that point and is no longer providing income to her. So her passing away after the annuity time frame is up has absolutely no impact on the Medicaid compliant annuity contract. The time frame to establish a Medicaid gift and annuity strategy, step 1 is going to be that we make the gift or the transfer. We purchase a Medicaid compliant annuity and we apply for Medicaid typically all in the same month. And again, going back to the reason why we do this is to establish that the Medicaid applicant is otherwise eligible for Medicaid, but for the fact that they have made a gift or a transfer. So they are resource eligible, they're income eligible, and they are in a Medicaid institution, or they're applying for a waiver program that will allow Medicaid to start the penalty period. Once the Medicaid application is made, Medicaid is going to look at the amount of the transfer, and they're going to determine the ineligibility period, and they will provide a Medicaid penalty period determination. So in this example, we already know that the penalty period is going to be 10 months based on how much was gifted. But we're going to actually receive that determination from Medicaid, and we're going to use the annuity payments to pay during the penalty period. After that penalty period is over, Mary would be Medicaid eligible after that 10-month time frame. There are a couple alternatives to a gift and annuity strategy. Some states will allow for a gift and promissory note plan. So instead of using the annuity, we would be looking at using a promissory note instead of the annuity contract. And generally, the promissory note is going to be between parent and child. But there are several states that don't allow for promissory notes in Medicaid planning context. So it may work in some states, it may not. The other strategy that we can look at is a gift in return or a partial cure strategy. There are some states that still allow for the partial return, and this essentially means that the client would be gifting away all of the resources, $185,000 in this case. Medicaid would assess a penalty period based on the full $185,000, and then gradually the giftee is going to return a portion of the money to the Medicaid applicant so that we are reducing the penalty period slightly or gradually, I should say, over that time frame. What if Mary has a limited life expectancy? So in our first scenario, Mary's family believed that she was going to live for another 20 years. Now in our second scenario, we're going to assume that Mary's family doesn't anticipate that she'll live more than 10 months. So 10 months again was the ineligibility period, and we talked about if Mary doesn't survive for that 10-month period, then the family really isn't gaining anything because Medicaid doesn't start paying in that first example until the 11th month. Our second option then is going to be to do a standalone Medicaid compliant annuity instead of gifting assets. So the goals of a standalone Medicaid compliant annuity plan would be to obtain immediate Medicaid eligibility without gifting or transferring assets. So there's not going to be any private pay period when we are obtaining immediate Medicaid eligibility and we are not transferring assets that would trigger a penalty period. We would also be trying to take immediate advantage of the Medicaid reimbursement rate. In this example, it was $8,000 per month versus paying the full private pay rate of $10,000 per month. I will warn you though that there are a couple of states that do rate equalization, which means that their Medicaid rate and their private pay rate is going to be the same. So if you're in a state like that, doing this second scenario or the second option really isn't going to be beneficial for your clients because there is no difference between the Medicaid rate and the private pay rate. And then another goal of a standalone Medicaid compliant annuity would be to create a wealth transfer to Mary's family after she passes away. Recall that if we do no planning at all, the $185,000 divided by our monthly deficit or our shortfall is only going to last for 23 months or less than a 2-year time frame. So instead, we're looking to eliminate the excess resources or the $185,000 by converting that money into an income stream by way of a Medicaid compliant annuity for Mary. Mary is going to be the annuity owner, the annuitant, and the payee. And based on Mary being 80 years of age, her remaining life expectancy is going to be 9.74 years or 116 months. So we structured this annuity plan over Mary's full life expectancy of 116 months. And you see that the monthly payment that Mary is going to receive each month is going to be $1,650 per month. The total payout at $191,400 is a little bit greater than the single premium used to purchase the annuity. And this is really just representing a small amount of interest that would be paid on the annuity contract over the term of the annuity. After the Medicaid compliant annuity is purchased and we converted the countable resources of $185,000 into an income stream, we're able to obtain immediate Medicaid eligibility for Mary and reduce her copay or her liability to the facility down to $3,600 per month. This number was determined by taking Mary's Social Security income of $2,000, adding the Medicaid compliant annuity income of $1,650 per month, and then subtracting out what Mary's personal needs allowance, in this state it would be $50, to determine that her liability to the facility each month is going to be $3,600 per month. The monthly savings that we were able to obtain by obtaining immediate Medicaid eligibility is $6,400 per month, and this was determined by taking the private pay rate of $10,000 and subtracting out the liability that Mary is going to pay to the facility at $3,600 to determine that the monthly savings are $6,400 per month. We'll assume that Mary passes away 6 months after the annuity is purchased. In this second scenario, the state Medicaid agency again is going to be the primary beneficiary to the extent that they provide Medicaid benefits on behalf of Mary. So Medicaid in this example is paying $4,400 per month towards Mary's care. And if she lives for a 6-month time frame, Medicaid would have provided $26,400 in benefits towards Mary's care. You'll see that we're using the Medicaid reimbursement rate at $8,000 and subtracting out Mary's copay each month at $3,600, and the amount that Medicaid provided on a monthly basis is $4,400 times the 6 months that Mary lived, so that the amount that Medicaid recovers is the $26,400. If we assume that Mary's children are going to be the contingent or secondary beneficiaries in this case, we are able to determine that the amount that Mary's children would receive is $148,700. This number was determined by taking the original annuity amount of $185,000, subtracting out the 6 months of payments that Mary would have received from the annuity during that 6-month time frame at $9,900 per month, and then also subtracting out the amount that would need to be paid back to the state Medicaid agency at $26,400 to determine that the wealth transfer or the amount that Mary's children would receive would be $148,700. The advantages of doing the standalone MCA plan is that we were able to obtain immediate Medicaid eligibility for Mary. We realized an immediate monthly savings of the $2,000 per month. This is the difference in the private pay rate and the Medicaid rate. Mary made a wealth transfer of $148,700, and you may recall from the gifting plan that we went through in the first scenario, the gift amount in that case was $105,552. So in this case, the wealth transfer is going to be slightly more by obtaining Medicaid eligibility right away versus doing the gift and annuity strategy. The potential disadvantages of the standalone Medicaid compliant annuity plan is that if Mary lives longer than what we anticipated, then the wealth transfer is going to be reduced accordingly. So the longer that somebody lives under the standalone MCA plan, the less of a wealth transfer that we're going to have for the intended beneficiaries, because the state having a right to recover for a longer period of time on the standalone annuity plan is going to continue to build up as the person is on Medicaid for an extended period of time. That's why we see in a lot of these scenarios, if we're not sure how long a person is going to live for, it is a lot more common to do option number one, where we know that we're going to save at least $105,000. Whereas in the second scenario, the longer the person lives, the less the actual wealth transfer is going to be to the intended heirs. We also need to know what the Medicaid reimbursement rate is for the facility that the person is in, because like I mentioned before, some states do have rate equalization, so you're really not obtaining savings in a state where the Medicaid rate and the private pay rate are equal to one another. If we then assume, instead of Mary passing away after a 6-month period, she passes away after a 12-month period, again, the state is still going to be the primary beneficiary and they would have a right to recover. In this case, it would be $52,800 that the state would have a right to recover. And we are seeing, as Mary lives for a longer period of time, the amount that they're able to recover is going to be greater and greater as she lives longer. So if she lives for 12 months instead of 6 months, then the children in this case are going to receive $112,400, because the annuity is again going to make payments for a longer period of time, 12 months in this case. So we have to subtract out the annuity payments that Mary received during the 12-month period at $19,800, and then also subtract out the amount that the state has a right to recover. And we see that the amount that the children are going to receive is going to be less as Mary lives for a longer period of time. How does the plan change if your client resides in an income cap state? The numbers again are not going to change at all, but because Mary would have monthly income of $3,600, this amount is greater than the cap amount at $2,349 per month. So the income must flow through the Miller Trust before the facility or before the cost of care is actually paid for. And since this income is being used to pay the facility, the numbers aren't going to change. It's just, again, an extra step that Mary must take in order for the income limitation to be met for Medicaid planning purposes if she is in an income cap state. The time frame or the steps to implement a standalone Medicaid compliant annuity: we would determine the spend down amount and purchase the annuity. Generally, this is going to be done in the same month. A Medicaid application is completed and submitted, and then Medicaid eligibility is immediately obtained because we spent down the excess resources by converting them into an income stream. And there would not be a penalty period or an ineligibility period in this case, because we did not make any uncompensated transfers or gifts to children or to anybody else. Which strategy is better? The first option, where we did the gift and annuity, or the standalone Medicaid compliant annuity like we talked about in option 2. The person's anticipated longevity is going to really dictate which plan is going to be better for them. But we also need to know what the Medicaid reimbursement rate is, like I've mentioned. And we also need to be aware whether the person, if the Medicaid applicant lacks capacity, the power of attorney documents must contain gifting powers for option number 1 to work. So there are some scenarios where we aren't going to go through the guardianship or conservatorship process. So option number 1 wouldn't work if the person does not have the ability, if the power of attorney does not have the ability to gift or transfer assets. So then we're kind of stuck with option number 2 if we're able to just convert the excess resources into an income stream. And then lastly, if we're working in a state that has an actuarially sound requirement, such as Oregon, Washington, North Dakota, where they put a restriction on how short the annuity time frame can be. If you are in one of those states and we can't use option number 1 because we can't make the annuity work with the person's life expectancy, then we're pretty much obligated to proceed with the second option. What about the Medicaid compliant annuity insurance carrier? So insurance companies are rated on a scale from A+ to D, depending on the rating agency. So if you're looking at rating agencies such as AM Best, Moody's, S&P, all of those are rating agencies that will rate the insurance company that the client is purchasing the annuity from. And you definitely want to make sure that clients are aware of what the rating of the carrier is going to be. There are state guarantee associations, which are similar to FDIC, which will cover the insurance company's product up to usually $250,000 or $300,000 based on if the insurance company would become insolvent or go out of business. So there's just a lot of different things that should be taken into consideration when we are looking at the rating of the company and how long the annuity is going to be structured for. So a rating may not be as important on a very short-term annuity like a 2-month time frame, because the insurance company is going to turn the money back around to your client very quickly. But if we're looking at an annuity that's going to be stretched out over the next 10 years, or an annuity that's going to be purchased with a lot of money that exceeds what your state guarantee association will cover, then we want to be cognizant of the rating of the insurance company when we are recommending which carrier we actually use for the Medicaid compliant contract. Why you should consider working with me and with Ashburn. I have over 15 years of experience working with elder law attorneys across the country to secure Medicaid eligibility for their clients. We do a complimentary case analysis, so this applies to pre-planning scenarios as well as crisis planning, where we will help to determine the optimal annuity amount, the term of the annuity, and which assets should be annuitized in order to obtain Medicaid eligibility. We only work with A-rated insurance carriers, so we are not working with any B-rated carriers when we are doing pre-planning or crisis planning. And we offer top-notch customer service to all of our agents and attorneys that we work with. And it does look like we have a couple of minutes left for some questions, and we do have some questions that have come up here. Okay, so we have a question about the gift and annuity strategy as far as why the shortfall is added to the penalty divisor instead of just dividing the spend down amount by the divisor alone. The reason why we don't just divide the spend down amount by the divisor is because there is a portion that we're trying to figure out how much we're going to fund the annuity with in order to create additional income during that penalty period. So let me actually go back to that slide. So if I were to just divide the total assets of 185,000 by this state's penalty divisor of $10,555, I would determine that the ineligibility period is going to be 17.5 months. And that would be assuming that the full 185,000 was going to be gifted. So instead of gifting the full 185,000 and to spend down the client to $2,000 or less, I need to have some of the 185,000 go into the annuity contract. In this case, I determined that the $79,448 would go into the annuity. The annuity, as long as it is purchased as a Medicaid compliant contract and it has all the Medicaid qualifying language, is not going to be considered an uncompensated transfer that the client would be penalized for. So if I divide the full $185,000 by the divisor, I'm determining that the client would be ineligible for 17 and a half months, whereas I don't want the full $185,000 to be an uncompensated transfer. I want to only have a portion of the $185,000 be an uncompensated transfer so that I can put other money into the annuity contract that is not going to be considered a gift, and the annuity purchase amount is not going to trigger an ineligibility period. So this is really just a way to add the shortfall to the divisor to determine, we call it the burn rate, and to figure out how much can be gifted versus how much can go into the annuity and still keep the client's total income under the cost of care. Okay, there's a question here about, is there a benefit for a Medicaid compliant annuity over a gift and return strategy? So I just got done talking about, if we did like a gift and return strategy, would be that Mary would gift away the full 185,000. A Medicaid application would be made, and Medicaid is going to divide the 185,000 by the divisor to determine that Mary would be ineligible for 17 and a half months. And with the gift and return strategy, each month the giftees are going to give a portion of the money back to the Medicaid applicant to shorten the penalty period and also provide the resources so that Mary can pay her nursing home bill. The real disadvantage of the gift and return strategy is that more and more states are kind of cracking down on the penalty period, not actually shortening with the gift and return strategy as the money is given back to the Medicaid applicant. So that's a potential disadvantage, because when we're dealing with the gift and annuity strategy, we are going into Medicaid with the intent that we already know how long the penalty period is going to be, and we're going to set up an annuity to pay during that time frame. Whereas there's more unknowns in a situation where you're trying to use a gift and return strategy, because some states have said that as you give the money back to the Medicaid applicant, you're not actually curing that gift because the person is becoming over-resourced when you give that money back. So I see the advantage of doing a Medicaid compliant contract because we are going into the Medicaid office knowing already what the penalty period is going to be, and we know that we have an income source to pay for that penalty period, and there's less unknowns that are out there with the annuity plan versus the gift and return strategy. Okay, somebody is asking about, for those of us in an income cap, isn't there also a cap on the amount of income that you can have on the Miller Trust? What if the annuity puts the applicant over the amount? So in an income cap state, we would be looking at the gross cap of $2,349 per month is the limitation on how much income a person can have before you have to set up the Miller Trust. Even in a Miller Trust state or in an income cap state, we would not want to create more income than a person needs to pay their nursing home bills. So there's not a need to do a Miller trust if the person's income is not over the 2349, but you would have that income flow through the Miller trust and still pay the nursing home. And I would not recommend setting up the annuity payment for more than the amount that the client actually needs to justify paying their medical expenses during that time frame. So there are a few other questions here that are asking state-specific questions, and so I will reach out to individuals directly to answer those types of questions. But I want to thank everybody for joining our webinar today. Please look out for information on our next webinar in March, and thank you all. Have a great week and take care.